Good afternoon. I'm Deborah Boffman, and thanks for joining us for the Legal Insights for Employers webinar that we're putting on this afternoon. We're happy that you could join us. You all will be on mute. There will be an opportunity to ask us questions in the Q&A box, and we'll try and get to those at the end of the webinar. Just as a reminder, this is the information we're sharing today is not legal advice. It is not intended to be legal advice. The information is only for informational purposes. If you have a specific legal question, feel free to reach out to any of us later after the webinar. So I'm Deborah Boffman. I'm in the tax practice group. I focus on employee benefits. I do help employers with retirement plans and group health plans, cafeteria plans, executive comp, stock options, HIPAA, COBRA, and any kind of benefit issue an employer might have. Joining me today are my partners, Patrice Aaron and Nikki Foley. They're both in the employment and labor practice group. Together, they have about 46 years of labor litigation and counseling of employers. They address all types of employment relationships from prior to being employed to employment agreements, severance agreements, employee handbooks, non-compete, and confidentiality agreements. They advise employers on how to avoid litigation, but they're really great litigators when forced to address issues in court. Also joining is my partner, Eli Morocco. He's the lead of our immigration group at Jaffe. Employers turn to Eli for both incoming and outgoing nationally employee immigration issues. He addresses immigration for all kinds of industries, manufacturing, finance, engineering, symphony orchestras, athletes. He has a solid background in finance and corporate business formation, so he's a real asset for employers that have immigration issues. So this is your panel, and we'll be helping you through some topics today. Next slide, including issues related to employment and labor, immigration, and benefits. And we'll also talk about things that we're paying attention to in the future. So our first question is to Patrice. She's going to address what employers should be considering for COVID safety compliance and hybrid policies that were implemented during the COVID pandemic. And so, Patrice, what are employers needing to consider now that we're sort of phasing out of the pandemic?
Yeah, thanks, Deborah. That's actually the interesting issue. We've heard a lot on the news media, and even as early as today, that there's an announcement that the pandemic is over and everybody's getting on with their lives. And some say the pandemic is still ongoing. Some say that it's over and now we are in an endemic phase. But ultimately, I don't know that we need to answer that question today for purposes of what your obligations are as an employer. Your obligations as an employer are articulated as far as the safety issues are concerned, that under the Occupational Safety and Health Administration, known as OSHA, and MIOSHA is the Michigan equivalent. Employers have a general duty to provide a safe workplace for their employees. And there's a number of guidance that OSHA has issued over the course of the pandemic, and those guidance and their recommendations are on their website at osha.gov/coronavirus. And it indicates on their website that there's going to be updated guidance that is coming soon. The website doesn't indicate when that guidance will be finalized or published, just that it is coming. So you should, as an employer, continue to monitor that as an ongoing basis to determine if there's any changes in the recommendations. But one of the things that employers need to be aware of is these are not required by law. They are not mandated. They are merely recommendations by OSHA. However, I think it would be risky to not follow the guidance that's been suggested, or the recommendations suggested by OSHA, because ultimately you would have to defend why your workplace is safe by not engaging in some of these very basic safety guidelines. Now, OSHA makes a distinction between, and so does the CDC, between vaccinated and unvaccinated workers. And employees should be familiar with the CDC recommendations. OSHA follows those and encourages employers still to provide paid time off for employees to get vaccinated. And OSHA also has a number of, they call it multi-layer controls, including making sure that you have the appropriate ventilation. That is something that we've seen gone way back to the beginning of the pandemic, and still recommends cleaning, social distancing, and time off to employees if they are symptomatic. But they rely heavily on the CDC, which is the Center for Disease Control, with respect to what employers should be looking at and should be doing as it relates to employees that may be at risk, or employees that are exposed to or contract the COVID virus. The fully vaccinated people don't need to take all the same precautions that unvaccinated people should take unless it's required by local laws. And other recommendations are also based on the vaccination or the risk level that's going on in various counties across the country. In Michigan, at least in the metropolitan Detroit area, Macomb is considered a medium risk, and Oakland, Wayne, and Washtenaw County are still at a high risk. So what does that mean? Under the recommendations, either whether it's low, medium, or high, the CDC recommends that all employees and all individuals maintain up-to-date vaccinations, that they get vaccines, that they're up to date on any boosters. And in all risk levels, the CDC recommends that if you're symptomatic, if you have any of the COVID symptoms, that you, as an individual, as an employee, be tested to determine whether you're going to test positive for those. The difference really is between medium and high, and that's really with respect to the recommendations for mask wearing. If the county is classified as a medium risk, then those individuals who are at high risk, if they contract COVID, should talk to their healthcare provider, determine whether it is recommended that they wear a mask, and in what circumstances they should or shouldn't wear a mask. If the county is classified as high risk, then the CDC recommends that individuals wear masks when they're indoors. The CDC doesn't distinguish anymore between vaccinated and unvaccinated individual. That's something that's sort of has periodically changed by the CDC. Currently, if it's a high-risk county, then the CDC recommends that those individuals maintain or wear masks. And also, they also recommend social distancing in those situations. The other distinction that's being made by the CDC has to relate or relates to what happens if you either are exposed to the virus, or if you test positive, or you're symptomatic and you test positive. And again, the distinction depends on whether you're vaccinated, unvaccinated, or whether you've had COVID within the last 90 days. And if you turn to the next slide, if you go to the CDC website on quarantine and isolation, you'll find these two, I guess I'll call them charts, for lack of a better word, that'll help you which is really a good tool to help you determine what you should be doing vis-a-vis your employees. And you can see there's a distinction made between if you're vaccinated and whether you're unvaccinated. If you're unvaccinated and you're exposed, then it's you should be quarantining for at least 5 days and wear a mask if you're exposed to other people. Look for symptoms during the next 10 days and then take precautions thereafter. If you're vaccinated and you are not symptomatic, then there's no need to quarantine or to isolate. And then obviously, if you test positive for COVID-19 or if you have symptoms, the CDC recommends that you isolate and you quarantine. And the charts are very useful for following specific requirements and also the time period during which you should be doing that. So you should continue to monitor both the OSHA website as well as the CDC website to look for those changes. They occur periodically. The last change was I think was last month. OSHA has announced it's going to be doing some updated guidance. So you should check on those to make sure that you're staying up to date on that.
Thank you, Patrice. So Nikki, at the start of the pandemic, we all started working from home. And as we're working our way out of the pandemic, every employer has different requirements for being back in the office or working remotely. Can you give employers some advice as to how to protect themselves from employee claims?
Sure, thanks, Deb. So I think the key to having an effective plan is really evaluating your entire workforce. And I think most employers have transitioned from a fully remote workforce to either a hybrid plan or a fully return to work. We're going to focus today on how to have a successful hybrid plan. And I think the key is having clear expectations and having your documented policies and procedures, making sure those are written down, making sure those are effectively communicated, and making sure those policies and expectations are enforced fairly across the board. And this really does apply to employers who are deciding whether or not they're going to transition from a fully remote workforce to a hybrid workforce. And it also applies to those employers who have been on a hybrid plan and are trying to reevaluate the effectiveness of their plan. So first and foremost, you need to determine eligibility for the plan. If your entire workforce is offered the option to work hybrid, this is less of an issue, except it could become an issue if you have to discontinue someone's eligibility, and we'll get to that a little bit later. If you are only offering some positions or some employees the opportunity to have a hybrid work option, then you have to think really carefully about the eligibility criteria. And only those positions that can be performed effectively both on-site and remote should be offered the option. And then only those employees who have demonstrated that they can perform at a high level of productivity and a high level of effectiveness. You should avoid making eligibility decisions based on longevity or title. And once you've decided what your eligibility criteria are, you should make sure that that's effectively communicated to your employees. Once you've got your eligibility, you should make sure that your expectations are very clearly set and communicated. There's no one size fits all set of expectations. Each company is going to be different. And in fact, even departments or teams within a company are going to have different expectations based on their needs. Let's look at a couple of different areas where you should be making sure you have policies and you're communicating those policies. So first would be a schedule. So what's your hybrid schedule going to be? For example, are you setting a plan that allows employees to work remote 3 days a week, but they have to be on site 2 days a week? Let's just go with that hypothetical. Once you've set what the plan is that going to be a flexible plan? Can they choose the days that they are remote on site? That affords more flexibility for the employee, but maybe less less of an option for employers to be able to enforce what those policies are. One thing to think about is if you are going to give a flexible plan, for example, if you have weekly meetings or you have one big monthly meeting, and your policy is you can have whatever flexibility you want, but you have to be in the office for that weekly meeting or monthly meeting. That flexibility can also sometimes lend itself to people creating a 4-day weekend. So if that's an option for employers, you might not want to allow that level of flexibility. You could set a stricter schedule. You can say, 3 days remote, 2 days in the office, but you employee have to set that with your manager. and you can't deviate from that. So we're not going to allow you to flex that schedule. It creates more predictability and accountability, but it does reduce flexibility for employees. So whatever you decide to do, make sure that those policies are in writing and communicated. Same thing with hours of work. So now that you have people on a remote and an on-site schedule, what does the schedule actually look like? Are you going to say, if you're on site, you have to be there 9 to 5? Are you going to have the same policy for when they're remote? That too takes away some flexibility. Other options are having core hours. So maybe while you're on site, you're working 9 to 5, but when you're remote, as long as you are available by phone, email, you're available for meetings, between the core hours of, let's say, 10 and 2 or 10 and 3. If you can reach them between those core hours, you're okay with that. And then they can work the remainder of their shift or the remainder of their expected hours anytime they want. So whatever option you choose or whatever option you're going to afford to them, make sure that that is also effectively communicated. The next topic is, tracking of hours. This isn't really any different than when employees, have been in the office. Just reinforce for them what the timekeeping policy is, how they track their hours when they're back in the office, how they track their hours when they are remote. Is it a punch clock system? Is it, logging into, Slack or some other platform? And that's how the, employers know that employees are online and working. Productivity is a big one. How are you going to measure productivity, both while they're back in the office and while they're working remotely? Is it based on hours logged? Is it based on their presence on a platform? Are there specific measurable objectives? What type of work is going to be done on site or remote? When they're on site, is it your preference that they're working on paper files or they're having in-person meetings? And when they're remote, you want them doing Zoom meetings or electronic communications or data entry, data tracking. Whatever your needs are, make sure those are communicated. And remind them that they have to be prepared either way. Don't let a lack of preparedness result in a lack of productivity. So what files do they need to be taking back and forth? What equipment do they need? Make sure that they are being responsible for having those things with them at home and bringing them back to the office so they can maintain productivity. Also remind employees that working a hybrid plan is a privilege, not a right. The company can change the plan at any time. They shouldn't have an expectation that they can stay on this program if they're not meeting expectations. Is there a lack of communication? Is there a lack of visibility? Is there a lack of productivity? And if those things are occurring, they need to understand that the privilege of working hybrid may be suspended or taken away altogether. And they also need to understand that there could be additional disciplinary considerations like written warnings or even termination. Once you have your expectations set and they're effectively communicated, make sure that you are fairly applying those policies. A big one where I see a lot of problems is timekeeping and visibility. Employees who are failing to meet those requirements, don't let a manager with a short fuse who's getting frustrated dictate that a particular employee is going to be disciplined or removed for hybrid when you know that there are other employees who are also having those same difficulties. Make sure that you are able to sort of monitor people's progress and make sure that the policies are enforced fairly. Don't let remote actions or issues slide. Make sure you're staying current with performance concerns. Make sure managers are emailing people if they're remote, if there are any issues. Make sure that you're addressing those issues face-to-face when they're working on site. And try as best you can to make sure any remote communications are documented to the file. And also try, when they're on site to have those meetings with another member of human resources and obviously document those conversations. Some other things to consider too when you're converting back to a hybrid plan is you might get some pushback from people who have been working remote for the last 2 years. You might also get renewed concerns with health risks of returning to the office, and Patrice addressed some of those issues on how to manage those health concerns. So there could be ADA accommodation requests. And you could also have health and or religious objections if your policies require on-site employees to be vaccinated. So you have to remember and consider that these issues might start creeping up again, and make sure that you're assessing those on an individual basis. And try really hard to, one of the main reasons that employers return to a hybrid policy is to sort of return to normal, or to return to the company culture that existed before COVID. Don't use that reason as a basis for denying an accommodation. Make sure you're evaluating, productivity and effectiveness. And if they can, work, maybe if they can work exclusively remotely and they are asking for a valid accommodation, then that's something that should be granted. And finally, just as a reminder, while you're evaluating all of these things, to sort of put out a reminder about remote work protocols. Remind them of, general safety protocols, having a clean workspace, and being, in an area that doesn't have hazards or distractions. Remind them about fire safety. Does their home have the appropriate, smoke detectors and fire extinguishers and accessibility to fire exits? Because people's remote workspace has probably changed over the last 2 years. Make sure they're using the proper electrical equipment, surge protectors, and things like that, that their systems are adequate for office equipment use. Remind them about having a good, healthy workspace, sufficient lighting, and their computer is at the right level. And make sure that they're following your security protocols. This is something that you should be reminding them about constantly, but don't disable the virus protection. Make sure you're putting away company, files and documents when you're not using them. So all of these things you should be evaluating if you are deciding if you want to implement a hybrid plan, or if you're trying to evaluate whether or not your hybrid plan is effective. Communication is key. Having written expectations, making sure those expectations are provided to employees, and making sure that your policies are enforced fairly across the board.
Thank you, Nikki. All interesting.
So I think we have our first polling question. If you wouldn't mind joining us and answering this question. When it comes to hybrid working, what are you most concerned about? And go ahead and check all that apply. Uncertainty about what to include in telecommuting policies, maintaining company culture and employee engagement, ensuring remote or hybrid work policies are applied fairly, or some other issue. And I think there is space there for you to specify what that issue is. I think we addressed most of these issues today, but certainly to the extent that they haven't been addressed and they are a concern for you, feel free to follow up with either me or Patrice after the presentation. So it looks like the biggest concern is maintaining company culture and employee engagement. That came in at a whopping 67%, with the second issue being ensuring remote or hybrid work policies are fairly applied. So certainly reach out to us if you have specific questions, and we can help you with those.
Thank you. So Eli, everyone knows that unemployment is very low, and there are millions of unfilled jobs. Seems to be affecting the economy and supply chain issues. What are some solutions employers might consider with respect to immigration?
Well, this is the moment when I probably would normally start out with a joke, but I think most of the employers that have been wanting for help for such a long time already probably have more tears going than laughs right now. So let's try to brighten it up for everybody and suggest that immigration can be at least one significant part of an overall solution to what is truly an epic labor shortage. Over the decades, this country, we normally worry about too many people being unemployed. And right now, we have somehow backed ourselves into a situation where we can't find enough good help. So how did we get here? At least briefly, because knowing the background and maybe reciting it and everyone has experienced it. But basically, when COVID hit in March of 2020, basically it led to a great deal of fear amongst the workforce, amongst the entire population in the US, but a lot of people became very afraid at some point along the way to even come into work at an office or a manufacturing plant, whatever their location. Plants and offices closed. Then the government stepped up to help those that needed help, which we were being provided with supercharged unemployment type of compensation available for people that couldn't get to work and couldn't get their wages. But to an extent, depending on how you feel about it, that may very well have crept into the psyche of the American worker. And we ended up with the Great Resignation, and a lot of people that haven't rejoined the workforce ever since they were temporarily forced out of it. Supply chain shortages have contributed to that as well. When you can't get your needed components and whatever else is coming, as part of your manufacturing process, people are laid off as well. And then the whole mix goes back and forth. But basically, we have large numbers of businesses and industries that are desperate for help. The good news is that the rest of the world, for the most part, considers an opportunity to come and live and work in the United States as being a real beneficial kind of a thing, a real opportunity. So finding a way to fill the gap for our workforce needs is still available as long as we can make a connection and you as the employers find the qualified candidates you want. Now, our firm doesn't engage in finding the candidates for you, but my experience has been that most of our clients do a terrific job at finding them. They may be overseas, or more typically, they will already be, these foreign nationals, already present in the United States, giving you just kind of a general idea of the usual pattern that we find for employing and then continuing to retain foreign nationals for employment needs are that most of them, I would say the vast majority truly, have either completed or are nearing completion of university. These are for skilled jobs, professional positions, typically, obviously, since these are bachelor's level or higher degree candidates that we're talking about. But as a part of their school program, there is what's called optional practical training and curricular practical training, OPT and CPT. And those are special regulated opportunities for these students to work while they're still in their F1 student visa category status. So for 12 months following completion of their undergraduate, or actually of any level degree program, graduate levels as well, they'll have certainly a minimum of 1 year opportunity to come work for a business that's in a field that relates to what their degree major was. And for those students that have been in one of the STEM degree fields with science, technology, engineering, or math as their degree field, that 1 year becomes a 3 year opportunity to work once again in something that's related to what their university degree program was all about. But what that does, it sets up the employer as having anywhere from a 1 to 3 year opportunity to try out, basically to screen the individuals and find out if they're good workers, if they like them, if they merit having some support to get other immigration types of work opportunities in the future. So the employer doesn't necessarily have to invest and rely on those individuals during their OPT or CPT periods of time. They can try them out and then decide if it's worthwhile to go further. So what happens as the next step is this ordinary pattern from student visa with practical training work experience. The professionals, which are called specialty occupations, fall under what's called the H-1B immigration visa status. It's a temporary work status. It's valid with extensions for up to at least 6 years. 6 years, but you can go longer, depending if you meet certain guide marks along the way, as far as sponsoring for a permanent resident green card later. And the H-1B category is a true favorite. The only problem with it in recent years is that the cap on the number of H-1Bs that is available each year is 65,000 for those holding a bachelor's level degree. and another 20,000 on top of that for those that hold a master's graduate degree type program. That total of 85,000 is it, with the exception of a few isolated nonprofits and cap exempt type of H-1Bs. For the most part, this limitation annually forces a lottery to be conducted each spring. Typically, currently it's each March, with employers submitting the proposed H-1B workers into this lottery. The lottery is conducted, and within 30 days, employers are notified if their lottery entries for these individuals have been selected as winners. And if they are, then they're given another 90 days in which to actually draft and prepare the entire H-1B petition package, which goes into the U.S. Immigration Service, the USCIS, which is U.S. Citizenship and Immigration Services. So H-1B is a staple, and it's usually, as once again, most typically part of the pattern, going from student OPT or CPT, then into H-1B for a number of years, and then a third and final stage, if this turns out to be an employee that was worthy of keeping long-term, then we look at permanent residency, or green card as it's generically called. And there's more than one way to get to a green card, and that's probably a little bit far afield for our discussion here today, but that is a way then to retain the individual once they approach the maximum number of years in H-1B, so that all the support and the reliance that you as an employer place on these individuals is not wasted and lost. You're able to find a way to retain them permanently. So that's kind of generally how the usual pattern works. And we're talking just generally how is immigration a part of the solution to the labor shortage? Well, what other solutions are there? In part, you can wait for more candidates to qualify by going through university programs, going through specialty training programs for other levels of immigration, visas and so on. But that takes time. And if you need somebody now and this year, immigration is also the quickest way to get to that answer. So just sharing over the last couple of years, when we've been dealing with the pandemic and the shortages, what have we been dealing with? What have employers and businesses been looking at? Well, they've been looking at shortages for engineers. Somewhat uniquely, there have been a tremendous shortage of field service technicians, individuals that are qualified and know their equipment and can do installations or punch list items following installation, or warranty work follow-up. There's a huge shortage in that area, which severely curtails the value of U.S. manufacturers acquiring the equipment. So much of it comes from overseas, lots from Italy and Germany and Japan and China. And once it arrives, it sits in the box, and there's nobody that they can bring in to implement it and get things working in the plant. It's a horrible waste from all points of view there. So that's another area where we found that it's been very hard to find employees. Other fields that we've seen through our clients, IT professionals, those in the computer science field. There's a variety of different things depending on the field you're in, and we do obviously all types of different work here. There's actually been a huge shortage of ballroom dance instructors, for example. So just for a variety, but things are working better now, is the good news to report, than they were during 2020-21. During those two earlier years, the vestiges of the Trump administration bans were still in effect. And those bans were put in effect during the pandemic for a couple of asserted reasons. One, because there was an interest in protecting the U.S. workforce so that U.S. workers wouldn't be rendered out of work, unemployed. So foreign nationals that ordinarily over the years were able to come into the U.S. were barred from coming in, even to the extent that owners of businesses, executives and managers of businesses were being precluded from being able to travel freely into the U.S. And frankly, our work turned into a bit of a cottage industry of trying to obtain national interest exceptions, basically waiving the bans on people like that. The other reason for the bans was from a health perspective, not wanting to bring foreign nationals, not allowing them into the country in case they would be bringing COVID virus issues with them. But we're now at a different point in time. The USCIS has different leadership. They have indicated in so many different ways that they're open to doing what makes common sense for opening up immigration once again, which should be music to the ears of all the business owners, on this call. Basically, to kind of, and not overdo this, but basically, what are the preferred choices? I gave you what the normal pattern is, but a preferred choice, if you have it available, if you have individuals that you want to come working for your business in the US, the first choice is always to look to the treaty, which is the US-Mexico-Canada Agreement, USMCA, formerly known as NAFTA. That is a super preferred route because of its ease of processing and the relatively few requirements imposed to be able to hire. The most broadly used of the visa categories under the USMCA is the TN category, which used to stand for trade NAFTA. That's for a whole list of professions, primarily those that have university degrees, but not exclusively, who can process right at the border, right at the port of entry, and obtain a decision not only on the same day, but usually within a couple of hours of arriving there. The exception to requiring a college degree, notably here, is for scientific and engineering technicians who are also in great demand here in the US, who are allowed to be approved for TN, even if they have just a couple of years post high school and some experience to go with it. And they'll be working in direct support of a degreed engineer here in the United States. All of those types of visas can be processed right at the border, and it's hugely advantageous for employers to work there. There's no minimum wage obligation attached to it or otherwise. And TN can typically be used with extensions forever. There's not a limit on it. So we recommend that wherever possible at all. Other than that, I'd like to just touch base very briefly on a couple of quick hitters here. The topic on, at least over the last couple of months, on a lot of people's minds has been the situation in Ukraine. Now that's 180, isn't it, from what I've been talking about? But it actually makes some sense. We have seen an opportunity for the programs that the US government has set into place in order to protect Ukrainians who are, refugees almost across the board because of the Russian invasion. To the extent that if we can find qualified Ukrainians to come here, and under the programs that the US government has made available, that's relatively easy compared to the usual work that goes into obtaining a visa for somebody. Those individuals, many of whom have engineering backgrounds, or even if it's not a professional position, they can feel the need for US employers in so many other ways. It's a no-brainer. So the programs that are available for Ukrainians, just very briefly, one is called United for Ukraine, the U4U program, which is available for any Ukrainian national who was physically present in Ukraine still on February 11. That's the magic date that the US government selected as a fair date to say that, yes, if you were in Ukraine on February 11th, you're presumptively in harm's way, and you have been you've been basically displaced from your home, and you are able to come to the US. All that's needed is an individual in the US to complete a financial declaration. Basically, it's a sponsorship without any legal obligation attached to it. And that is submitted, and typically within a few weeks, the USCIS reviews it, and permission is then given for the Ukrainian individual and their families to board a flight and come to the US. And that's it. And that's valid for a minimum period of 18 months initially, with potential for extensions and renewals of that program. A little bit less likely for Ukrainians for an employer to be using is the Temporary Protected Status Program, TPS, which was made available by the U.S. government a couple of months ago, and that applies to Ukrainians that were already present in the U.S. So we're not looking to help them like as under the U4U program to be able to come to the U.S. These are people that were already in the U.S. as of on or before April 11th. That's the cutoff date there. And they will pretty much automatically, just by filing an application, be granted TPS status, which allows them to remain here, also for a period initially of 18 months, but high potential for renewal of the program. And the beauty of both these programs for Ukrainians is that the individuals, when they apply, they can request employment authorization as well. And there's the benefit. That's where we help with the employment situation. So there's lots more going on with immigration, but I think I'm going to probably surrender the microphone. And at this point, back to you, Deb.
Well, we have a polling question, if you want to offer it up to our participants.
Certainly. The question is the labor shortage impacting your business performance? Is it currently impacting your business performance? And the choices are pretty simple. It's either a yes or a no or an unsure. Just choose any one of those, please. And that will tell us a lot. And for those on this webinar, it'll each of you tell about your colleagues and your peers. In fact, what's really important to you and what's not. So when the results roll in, we'll find out if our own experience here is just from a limited point of view or if this is really accurate. So here we go. So nearly 2/3, 64% said yes, labor shortage is currently impacting business performance. And I think that's very meaningful, in this world and for our country. Lesser numbers for no and then sure. So thank you for all your responses to that.
Thanks, Eli, for that insightful look at the immigration issues. I want to switch gears now to employee benefits. We've been discussing pertinent employee benefit topics on the minds of employers. And Deborah, we've seen, at least during the pandemic, lots of proposed legislation throughout the pandemic. And I wonder if you could give us an update on where policies stand today and what's going on in the benefit arena.
Sure, thank you. So during the pandemic, there was 4 major pieces of legislation that was enacted that addressed employees and employee benefits. The first one was enacted in March of 2020, and it was the Families First Coronavirus Response Act. And if you recall, that was when the legislature decided that they should expand paid leave for people that were affected by the coronavirus or by being forced to quarantine. And so it was extended family leave acts and the employers paid for the leave that they wouldn't normally have provided, and the employers were able to get reimbursed through tax credits. Then about 2 weeks later, or maybe even less than that, there was the CARES Act. And if you'll recall, that was provided for participants to take up to $100,000 out of their 401k plan without paying the early distribution penalty. That was the legislation that gave us the payroll protection program and employee retention credits. There was 2 draws for the payroll protection or PPP program, and most of that has been forgiven. There were loans to businesses and state and local governments. That also gave us the rental relief where people couldn't get evicted from their apartments for the lack of paying rent. The Department of Health and Human Services and the Treasury both decided that the timing of COBRA notices and disclosures and other types of notices that are required under ERISA could be extended. They would disregard the current statutory timelines and deadlines, expanded unemployment benefits, and that was the legislation that also froze student loan repayments and stopped accruing interest. That still is in effect, but will expire at the end of August. Then there was the Consolidated Appropriations Act, which essentially just extended a lot of the CARES programs. And then lastly, in March of 2021, there was the American Rescue Plan Act that gave us a national vaccination program. It got money directly to families. It supported hard-hit communities. It suspended COBRA premiums, again, so that employers could get reimbursed for them. They filed that on their federal tax return for withholdings, the 941. And also something that was not related to COVID specifically, if you have a single employer defined benefit plan, the legislation changed the funding targets by increasing the interest rates that could be used. So that really provided a big benefit to people that are still maintaining defined benefit plans. Unfortunately, there isn't a lot of guidance on that yet. So then the outbreak period. So former President Trump declared a national emergency because of the pandemic, effective March 1, 2020. And so the outbreak period under that legislation and under other legislation is the extent that there's a national emergency plus 60 days after it's announced to be over. So during the outbreak period, which we're still in, President Biden just extended it in March indefinitely. The notices that a participant is to receive from an employer, the election itself, the premium payments, and special enrollment rights are all extended for the lesser of, or the sooner of, the end of the national emergency, the end of the outbreak period. So whenever President Biden or whoever declares it to be over, plus 60 days, or 1 year from the date that the event happened. So if I'm supposed to make a COBRA election by, say, May 1st of 2022, I have until April 30th of 2023, or sooner if the pandemic is declared over or the national emergency is declared over, I had that entire period of time to make the election as opposed to just the 60 days. Same with the employer providing the election notice. However, an employer has to be reasonable. You know, they have to act in good faith and provide the notice as soon as possible. I certainly wouldn't recommend any employer wait a year to give a COBRA notice with a retroactive opportunity for an employee to elect back a year of coverage and then wait a year to make premiums. So that's still in effect. You need to be careful of your COBRA notices, what they say, and be ready if the pandemic, if the national emergency ends, to let people know that their coverage will end sooner than they might have thought. Then, so trends. So that really those are the only sort of benefits issues that are still out there from COVID legislation. What we're seeing is a lot of employers are looking at their benefit packages and really focusing on a couple of things going forward. Those employers that already have childcare programs are enhancing them, or if they don't already have a childcare program, they're creating them. It became very obvious during the pandemic how little coverage parents have to take care of their children. The other interesting benefit that we're seeing is senior care benefits for those of us who are caring for a parent or another loved one. That's a real new trend. There's a lot of emphasis on mental health, emotional health, financial health. There are all kinds of new programs that are being offered to help employees handle these difficult topics. In terms of one that I find interesting is help with student loans through 401k plans. There's a private letter ruling out there that an employer requested a ruling that it could help employees pay their student loans, not by reimbursing them directly, because that would be taxable income to them, but they're assuming that because this individual has to make a student loan payment, it doesn't also have the resources to make a deferred contribution to the 401k plan. So the IRS approved that this employer could make what is essentially a matching contribution based on its plan terms to these individuals in the plan. So even though they weren't contributing, the employer was contributing a non-qualified contribution, so that by the time an individual was able to afford to start deferring, they were already building up retirement income. So, you know, that's a really interesting benefit for all these young people or older people that have big student loans. And lastly, I just wanted to remind you, these are not COVID related, but since I have your attention, there's 3 things that are happening really currently or happening soon. As of July 1st, so in a couple of weeks, your group health plan has to provide information on what different services cost for in-network and what the service costs that they have history of claims out of network. And you have to make that available. So either your insurance company's got to make it available if you're fully insured, or you need to, if you're self-insured, you're going to need to work with your service provider probably to get this available to all your participants. Again, that starts July 1st, and then there's going to be an opportunity later to do prescription drugs, but there's currently no deadline for that. Then also the IRS requires every retirement plan to be restated every 6 years. We're currently in the 3rd restatement cycle, and that will end July 31st. So if you have a pre-approved plan, which used to be called volume submitters or prototype plans, they need to be amended completely, restated, and adopted before the end of July. And lastly, the Secure Act of last year included the concept of long-term part-time employees. Historically, retirement plans could keep an employee out of the plan and receive contributions if they didn't work at least 1,000 hours. So the IRS has now changed it so that if you have an employee who for the past 3 years has worked at least 500 hours, at the end of the 3-year period, 3 consecutive years, they can participate in the plan, and they will become eligible, and they'll become able to participate not only to make elective deferrals, but if there's employer contributions, they will be entitled to those. So the first year that an employee would be able to be eligible to participate would be in 2024, because the legislation started counting in 2021. So 21, 22, 23, if they have 500 hours, they're going to be able to participate in your retirement plan in 2024. And I think that's all.
So that brings us to the 3rd and final polling question. And the question is, as the benefit landscape changes, which would you like to be informed about? ERISA compliance, Secure Act 2.0, which passed the House of Representatives. It's sitting in the Senate at the moment. Non-qualified deferred compensation plans. If you could select one or more of those. Oh, this asks for a single choice. If you can select the one that applies to you.
ERISA compliance.
And by a whopping 83%, ERISA compliance is what's on the minds of most of the employers that are on this webinar.
And that's fair because it's so complicated. So certainly reach out if I can help you in any way. Okay, so as we look out on the horizon, these are a few topics that we are keeping abreast of and watching closely. The Secure Act, which Patrice just said is passed the House of Representatives and has just been issued out of committee in the Senate. There's no sign that anything's going to happen in the next, before the July 4th break. But you should pay attention to that because it has significant changes for retirement plans. It will require new plans to have automatic enrollment and automatic increases of contributions. It'll enhance catch-up contributions. It'll allow SEPs and simple IRAs to have Roth contributions. It'll allow employees to elect to have an employer matching contribution treated as a Roth contribution. It's over the next 10 years, it'll increase the age for taking required minimum distributions to 75. It'll expand qualified charitable contributions out of your IRA or your retirement plan. So keep an eye on that. There's lots of changes that'll have to go into effect if it gets passed. Eli?
I think the next item that was showing on the screen on the horizon is, are we going to get Congress to actually get off their rumps and make a change in immigration law? We've long been waiting for that, and it's been very, very difficult to do. Or are we going to continue to have to settle for, although it's extremely helpful for what I'm calling ingenuity of USCIS. We have seen over the past year several different ways in which the USCIS has made things better for immigration and people in general. One example would be for both the L and the E categories. The L is the intra-company transferees whose spouses, whether husband or wife, have always been allowed to apply for employment authorization, but until recently it was taking between 9 and 12 months to get an application like that approved. Same thing for the E2, which is the treaty investor or treaty trader, and the spouses similarly had permission to apply, but it took the better part of a year to get it. What the Immigration Service has done in the last few months is to automatically consider the spouses of both the L1s and the E2s intrinsic within their status as being allowed to work, so they don't have to submit an application or wait any longer. They arrive in the US and from day one, they're allowed to work. So we hope to see more of that, but better yet would be an exhaustive review of immigration by Congress and new statutes, but we're not holding our breath.
And on the employment front, we're continuing to monitor changes in either OSHA and CDC, as well as the development of the case law as we work our way out of the pandemic. But one of the things that I'm looking at, Nikki and I are both watching, is at the beginning of the pandemic, the EEOC, when it classified COVID-19 as a pandemic, gave the employers a lot more ability and flexibility in terms of how it handles its employees and what questions can be asked and things of that nature. And as the pandemic wanes, we're looking to see if the EEOC is going to downgrade its recommendations and permissions from a pandemic to an endemic, which can limit what questions employers can ask, et cetera, as it relates more of like your seasonal flu, things of that nature. So we're keeping an eye on any actions on that front.
Thank you. So we have a couple of questions and we're running out of time, but Patrice, what advice do you have for employers and employees managing a new era in the workforce?
Well, I think one of the things that, as I mentioned, employers always need to be mindful of what new regulations, recommendations are coming out in terms of COVID-19. And as I said, the OSHA is going to be issuing some new guidance, at least that's what their website has indicated. And also monitoring and enforcing their hybrid work policies on a consistent basis to ensure that they don't inadvertently give rise to a discrimination or a disparate treatment case, and also making sure that they're monitoring hours worked by hybrid workers as well, so that they don't inadvertently become subject to wage and hour claims when they've got people working at home. It's a little bit more difficult to monitor work hours that way. So making sure that they have systems in place, that those systems are followed, and making sure that they're enforced on a consistent basis.
Thank you. We had one other question and it was real specific about immigration. So I will make sure Eli gets that and someone will get back to you. Thank you for joining us. Everybody will get a copy of the slides and I think maybe a recording of the presentation. If you have any further questions, the last page of the presentation or the slides has all of our contact information, and we really appreciate you spending some time with us. Thank you.